Hey everybody, Matt Johnston here, and I'm going to be talking a little bit about an Equal Pay Act case. Um, there was a financial services company out of northern Mississippi that recently entered into a consent decree, which is basically a court-blessed settlement agreement, that this company would create an equal pay policy and end its practice of inquiring about applicants' prior earning history during the pre-employment hiring process. So, most people may not be aware, but the Equal Pay Act is also, it's about 58 years old. It was signed into law by President Kennedy, and the purpose obviously was to end pay disparity based upon sex. Now, I'm not going to be particularly interested in listening to comments or reading comments about the pay discrepancy and those sorts of things based upon a lot of myths out there. That's not the purpose of this video. This video is to tell you, if you are still asking questions about an applicant's prior salary history, stop. Stop doing that. Don't do that. It is a quick way to find yourself into a complaint process with the EEOC, or, as happened with this financial services company, find yourself in federal district court being sued by the EEOC. So don't do that. Now, there are some other kinds of screening practices out there that also violate Title VII of the Civil Rights Act. Now, just as a reminder, Title VII prohibits discrimination on the basis of sex, race, color, religion, or national origin. So that's the sort of the big five. That's what the EEOC is tasked with overseeing. So you cannot engage in pre-employment screenings, pre-employment questions, application questions that involve violations of the Civil Rights Act, Title VII. So get away from the practice of asking questions about somebody's race, religion. You'd be surprised, these things still happen. Pay history is often included in those kinds of pre-employment questions. So just simply don't ask those kinds of questions. If you're worried about whether or not your particular pre-employment questioning or screening process is a violation of the Title VII, please consult counsel. How you doing? But also be sure you are checking through regularly your process, not just for federal prohibitions under the EEOC, but also state prohibitions. For example, you cannot inquire about somebody's marital status. Even if somebody comes into your office obviously pregnant, you cannot ask about pregnancy. That's a discriminatory action, and you cannot refuse to hire somebody simply because they are pregnant. So these kinds of screening, these kinds of questioning, it still happens, as we can see in this recent settlement with a case out of Mississippi. So please, if you are going to be conducting pre-employment screening, make sure you are screening for experience and qualifications only. That's it. Anything else is going to lead you down a negative road, and you really don't want to be there. In the meantime, if you would like to and be so kind as to subscribe by clicking the button that's going to show up right about here. Also hit that little bell button down there that will tell you when I am posting new videos. I try and post new videos at least a couple times a week, or at least once a week, but sometimes a couple more times a week. And if you want to see some other content, you can check us out over here. If you want to speak to us, you can click the link that is included in the show notes and schedule a consultation with us. In the meantime, have a good day. Stay safe out there. Bye-bye.